Hello everyone, my name is Ashraf.
My name is Kelsey, and today we'll be talking about the case of Donoghue and Stevenson,
Also known as the Snail in the Bottle case.
So what happened in the case?
Well, it all began on a warm evening on Sunday, the 26th of August 1928 in Scotland. At around 8:50 p.m, a lady named May Donoghue and her friend went into a cafe, as they were rather thirsty. Mrs. Donoghue's friend ordered a drink, popular in Scotland, called pear and ice. The owner of the cafe, Mr. Francis Magella, brought over a tumbler of ice cream and poured ginger beer on it from a brown opaque bottle labelled D. Stevenson, Glen Lane and Paisley. However, what seemed to be an act of generosity turned into one of the most well-known cases in the law of tort. Mrs. Donoghue was rather enjoying her float, but after she consumed almost half of the bottle, something unpleasant was discovered.
Could you tell me what was discovered?
The decomposed remains of a snail floated out, causing her alleged shock and severe gastroenteritis. Mrs. Donoghue then alleged a claim against the manufacturer of the ginger beer, Mr. David Stevenson. She claimed that Mr. Stevenson should pay compensation because her illness was caused by the snail found in the beer. Mr. Stevenson argued that he was not liable, as there was no contract between them. This case was brought to the court, where it became a pretty big step in the concept of duty of care in the tort of negligence. Before this case, the duty concept was limited to situations which were contractual or similar to a contract. Because there was no contract between him and Mrs. Donoghue, Mr. Stevenson was confident that he would win the case before the court. Unluckily for him, the House of Lords decided to unshackle the duty concept. Lord Atkin concluded that love your neighbor in law should become you must not injure your neighbor. This was known as the neighbor principle, which will be discussed today. So even though they were total strangers, Mr. Stevenson was expected to ensure the beer produced was safe and clear of snail bits. It was concluded that a manufacturer has a responsibility to ensure that their products do not contain anything that will cause us harm. Now, let's go back in time prior to the occurrence of the case of Donoghue and Stevenson.
Before Donoghue and Stevenson, case law established that a duty of care, which is a legal duty to take reasonable care not to cause damage to another, can't be owed in the absence of privity of contract. The case law was Winterbottom and Wright, where the claimant was unable to sue the defendant for failure to maintain the condition of the horse-pulled mail coach because there was no contractual relationship between the parties. However, the law of negligence at the time was narrow, so the courts began to acknowledge duty of care regardless of whether privity of contract was present. This was illustrated in Heaven and Panda, where the claimant successfully sued the defendant for injuries suffered as a result of the defendant's negligence, although there was no contractual relationship between the parties. Brett M.R. suggested a wider duty of responsibility to persons who might be injured where ordinary care and skill were not exercised. This obiter was expressly adopted by Lord Atkin in Donoghue and Stevenson, when the test for duty of care, which is the neighbour principle, was established under English law. Thus, it can be said that Heaven and Panda foreshadowed the birth of modern law of negligence.
Now, the consensus of the ratio decidendi did not come easy. There was a lot of consideration needed to be addressed.
Here is Megan and Qian Hua to further explain.
Hi, my name is Qian Hua. So Megan, can you tell us more regarding the basis of this case?
Well, in this case, involving judges were Lord Buckminster, Lord Atkin, Lord Tomlin, Lord Tankerton, and finally Lord Macmillan. Now, the consensus of the establishment of the neighbour principle is not a unanimous decision. The leading judgment delivered by Lord Atkin himself is actually a 3-2 majority, with Lord Buckminster as well as Lord Tomlin dissenting, which actually had a major effect on the verdict. The foundation laid out was that the product in question was a manufacture of article intended for consumption. Now, from a logical standpoint, right, it should be the manufacturer's fault that content contained in the opaque bottle prevented inspection. Thus, manufacturer owes foundation to her as a consumer of article to take care that there's no nauseous element in the goods. As such, because he neglected such a duty, consequently he should be held liable.
So, tell me, what was the complex effects in the court when they realised an absence to claim in tort?
Well, the first effect stemmed from that precedents prior to this case would need justification if the lords were to depart. The earliest case to be considered is Langridge and Levy. In this case, a man sold a gun to the purchaser's son, which subsequently exploded in the hands of the son. The judgment of Part B still emphasized that we should pause before making a precedent even of instruments which are of danger themselves. This undoubtedly affected their willingness to depart and should be recognized as it will impact the law of tort and the extent of product liabilities. Next case to be considered is Mullin and Barr and Co. A case which is indistinguishable from the present, excepting upon the ground that it was a mouse that was found instead of a snail, and necessarily adopted by the second division in their judgment. Lord Anderson raises on a contrary angle. It was said that in this case, like the present, where the goods of the defenders are widely distributed throughout Scotland, it would seem little short of outrageous to make them responsible to the members of the public for the condition of the contents of every single bottle which issues from their works. Now, it is obvious that if such responsibility attached to the defenders, they might be called on to meet claims of damages which they could not possibly investigate or answer, feeding into the floodgate argument. But reverting back to the case as stated by Kelsey of Winterbottom and Wright, a closely applicable case, Alderson B. statement was also utilized to draw a different angle. The quote used was that the only safe rule, is to confine the right to recover in those who enter into a contract. Because if we go beyond that, there's no reason why we should not go 50.
So, what case was it then that truly persuaded the courts to depart from this precedent?
So, the ratio desiderandi of the case can be presented to lack immediate clarity and consensus until the reference case of Longmaid and Holiday, as the aforementioned judge, Part B, further extended on his verdict. This was when the judgment did change and slightly slanted towards another angle. So, in his judgment, it covers the case of manufacturer, for he said it would be going much too far, that so much care is required in the ordinary intercourse of life between one individual and another, that if a machine not in its nature dangerous, which might become so by a defect entirely unknown, although discoverable by the exercise of ordinary care, lent or given by one person, even by the person who manufactured it to another, the former should be answerable to the latter for a subsequent damage accordingly by the use of it. Now, this injustice formed the basis of the final desidendi, as the neighbor principle will play an important part in humanizing humanity. Furthermore, providing a magnificent vehicle to enable us to discuss what is acceptable and proper conduct, and draw a line from unacceptable and improper conduct. Now that we have explained the consideration and the deliberations which led to the establishment of neighbor principle, could you then further explain to us whether the court made a rightful decision and what was the significance of this case in tort of law?
Thank you. In Donoghue, Lord Atkin attempted to lay down the general criteria which had to be satisfied in order for a duty of care to exist. So in doing so, his lordship established the neighbor principle, stating that you are to love your neighbor, becomes in law, you must not injure your neighbor.
So my question now is that who it is that should be considered as a neighbor?
His lordship Atkin also included in his leading judgment that a neighbor would be someone who is so closely and directly affected by my actions that I ought to have them in my consideration as being so affected when I'm directing my mind to the acts or omissions which are called in question. This means that neighbor-in-law is dependent not on physical proximity but proximity in law. Meanwhile, in order to establish a duty, the damage would also have to be reasonably foreseeable. Together, these two factors formed a dual-limb objective test for which the court would use to establish a duty of care in future cases.
So now my question is, how is it that the principle should be applied?
The neighbor principle was subsequently applied in the case of Home Office and Dorset Yard Co. Limited. So in this case, a group of young boys escaped a Borstal home and caused damage to the claimant's yacht. So in this case, the defendants were responsible to care for the Borstal boys during their stay at the home. So the court held that the defendants owed a duty of care to the claimant because the two requirements of the neighbor principle were fulfilled. In this case, there was sufficient proximity between the defendant and the young offenders, as the defendant was in a position of control. Also, it was reasonably foreseeable that the damage could result from the defendant's inaction.
Thank you, Jenny, for your explanation. It really cleared any doubts concerning about neighbor principle itself. So now we will call upon a witnessing lawyer from the case of Donoghue and Stevenson to further explain what has progressed and what she can see has differed from the case of Donoghue and Stevenson.
It is essential to take into consideration that Donoghue was a milestone in a new principle which needed improvements. As Lord Reid said, the well-known passage in Lord Atkin's speech should, I think, be regarded as a statement of principle. It is not to be treated as if it were a statutory definition. It will require qualification in new circumstances. The subsequent crucial evolution of the neighbour principle came from the case of Hadley, Bryan and Heller and partners, which concerned economic loss and negligent misstatement. However, the locus classicus on the neighbour test can be discovered in another economic loss case called Caparo Industries and Dickman. What emerges is that in addition to the foreseeability of damage, mandatory ingredients in any situation giving rise to a duty of care are that there should exist between the party owing the duty and the party to whom it is owed a relationship characterized by law as one of proximity or neighborhood, and that the situation should be one in which the court considers it is fair, just and reasonable that the law should impose a duty of a given scope on the one party for the advantage of the other party. Thus, the requirements to establish a duty of care today are foreseeability, proximity, and fairness, also known as policy considerations. However, there has been a certain degree of overlap between the requirements, with Lord Hoffman stating that the distinctions between them somehow are porous, but there are probably none the worse for that. Even though there are certain overlaps, Donoghue and Stevenson may be said to have laid down a good law. If a claimant can prove the three elements, foreseeability, proximity, and policy considerations, a duty of care will be established against the defendant.
Thank you very much.
We hope you enjoyed our video
On Donoghue and Stevenson.
And the neighbour principle. Once again, my name is Qian Hua.
And my name is Megan.
My name is Ashraf.
And my name is Kelsey.
See you next time!